everybody, and welcome back. We are pleased to welcome attorney Robert David to Power of Attorney. Our hot topic today is medical malpractice, and we have certainly heard the stories of lives that have been lost or injured because of medical mistakes. Perhaps it has happened to you or someone you know. Well, what should we all know when it comes to this area of the law? Attorney David is here to help us all out.
My friend Robert David has been practicing law since 1969 and has been named by the Woodward and White Law Guide as one of the best lawyers in America 16 consecutive times. Robert, thanks so much for being with us here today. It's really a pleasure to have you here to discuss this topic.
Good to be here, John. Thank you.
It's a big topic. It's a serious topic. So let's just start with the basics. We've heard the term medical malpractice, medical negligence. Are we talking about the same thing? And what are we talking about?
You are. Medical negligence, malpractice are the same thing. They both mean a departure from the right standard of care. It's good medicine versus not good medicine.
And it happens often.
Yeah, and just to add to that, basically, we're not talking about Monday morning quarterbacking here. Everybody knows doctors are only able to do so much. If you get a bad outcome, that doesn't mean medical negligence or malpractice. It's when a doctor does something that no doctor is supposed to do. If the doctor goes left, but every doctor who's worth his or her salt knows to go right and a harm results, that's medical malpractice.
Yeah.
To try and say it in a different way.
So give us some idea, because I came across a really alarming statistic that was put out by the Institute of Medicine. It reports that between 44,000 and 98,000 people die in the United States in hospitals yearly because of medical errors. How serious of a problem is it here in Louisiana?
I'd say Louisiana is no different than the rest of the states. It's pretty much the same everywhere. You divide 50 into that number and you'll get the number in Louisiana.
So thousands of cases.
Thousands.
Thousands of cases. And in many instances, are cases going unreported?
Most of those cases that you talked about, Harvard did a study about this, and they said that, I don't remember the exact number, I think it's about 80-something% of the cases are not sued upon, whereas 20% are. And that many of the cases that they investigated where there was no malpractice do get brought into litigation.
Yeah.
So just to add to that, because I also in my office work in the field of medical negligence, medical malpractice, and I've worked many times with Robert David on medical malpractice cases. Many people, they don't know that the bad that resulted came from negligence. They're not doctors. How would they know? Number two, people who suspect that there's medical negligence, they say, well, what can I do about it? I don't know how to do anything about it. What ends up happening is only a small percentage end up going to lawyers who practice in this area. And then many lawyers say it's a close call. And even if we think something went wrong here, the medicine is, it's hard to nail it down. So, but most people never figure out that something that should not have gone wrong, that could have made the difference, went wrong. That some doctor, a hospital, somebody is actually, they committed negligence, and maybe the person would still be alive, or maybe that person would be doing much better but for this negligence.
So how do we deal with that? Because there is a statute of limitations on these types of cases, correct?
A very strict and short statute in Louisiana. You have 1 year from the date of the malpractice within which to file a claim, or else you lose all your rights, or 1 year from the day that you knew or should have known. But under no circumstances can it be more than 3 years from the date of the medical negligence.
So, wow, it's really, when you think about it, it's not that much time. I mean, if you have a family member who passes away as a result of a medical error, it may take you a while before you even decide to look into that case. Or we certainly have heard of cases where people have been walking around and they've had sponges or instruments that have been left behind as a result of surgery. But you're saying, let's say something like that does happen, and that's not discovered until like 4 years after the incident. Am I just out of luck?
You are out of luck. I regret to say that I've had some cases like that where people have presented where it seemed to be a case of malpractice, but more than 3 years had gone by. It's all over.
There's nothing that can
your
be
case
done.
will be dismissed right after you file it.
Right. So let me emphasize that point, because a lot of times it's confusing to people who don't practice law. Maybe you had a surgery. Before the surgery, the doctor has, he or she has the sponges, and they count the sponges before surgery. I got 15 sponges. They use the sponges to soak up the blood so they can see what they're doing. At the end of the surgery, before they sew you up, they count the sponges again. If they don't have as many sponges at the end of the surgery as when they started, they don't sew you up. They got to get the sponges. That's an easy example. They don't count the sponges. They sew you up. You don't notice the sponge in your stomach or whatever part of your body. 2-3 years can pass. You're feeling a little bit funny, or you go get an X-ray for something else, appendicitis. Hey, you got a sponge in you.
Discover it.
3 years after the fact, our legislature passed a law for doctors and hospitals saying that's too late. Now, but let me ask this, Robert. Some critics will say, well, you know, doctors, they're not gods. They can only do so much. They spend a lot of money getting their education. They deserve it's not like a car accident case. They deserve to have some of these, call it special treatment. This 3-year rule doesn't apply if it's a other type of injury. If you build a building and the building has defects in it that nobody discovers for 5 years, you can still be sued. But the critics say, you know, doctors, they're under a lot of pressure. They deserve this special treatment. What do people on the side of the injured patients say in response to that?
Well, if any one group has been given special privileges and protection, it is the healthcare industry. Not only is the statute of limitations quite short, but there's a cap on damages, a small cap on damages. In 1976, a law took effect that said that no matter how serious your injuries, no matter what your wage losses are, the most you can ever recover is $500,000. It was later amended to add medical expenses. Today, it's still $500,000. And today's dollars are not worth what they were in '76. So if in 1976 it was fair to cap damages at $500,000, today that $500,000 is the equivalent of $125,000.
Wow.
Well, let me ask you, I'm going to play devil's advocate because I represent injured people, and I have personal opinions aligned with the injured people, but the critics would say, well, you know what, this is a tough economy, medicine costs so much money, if we don't put a cap on medical expenses, people won't be able to afford medical care, doctors won't be able to afford doctors won't be able to afford insurance, malpractice insurance. We have a chart that talks about this, but I'm going to let you get to that chart. I don't know if you've seen this chart. This chart we put up on the screen, our researchers found a chart that says of all the money that goes towards healthcare costs, the money that is actually spent to pay medical negligence claims as of 2007, 0.3% actually went to pay medical negligence claims. How does that fit in with this debate?
0.3% is a pretty small number when you stop to think of how much the injured victim is injured a second time. Because in that 0.3% is included the amount that they pay their doctors to defend them. And I'm just going to take a guess that that's half of your expenses right off the bat. So that number is really not significant in the overall global picture.
These cases are very expensive to bring forth.
They are quite expensive. Before, the lawyers who know what they're doing in this field of law, before they will file a claim against a healthcare professional, will get the file reviewed by a doctor. It has to be an out-of-state doctor most of the time because Louisiana doctors are loath to testify against other Louisiana doctors. So these doctors will charge several $1,000s to review a case on top of the cost of getting the medical records. So before you even take a case to panel, you should know that you have one.
Right.
You shouldn't file frivolous claims.
We're running short on time for this segment, but you make an interesting point. Before you could bring a lawsuit in the courthouse like you would with just about any other case, doctors, medical malpractice cases against hospitals, doctors require that you go to a medical review panel. Why don't you define what a medical review panel is, what it's for?
Before you can file a suit, this is another protection that the healthcare professionals enjoy. You have to first present your case to a medical review panel, a panel of 3 healthcare professionals, almost always doctors. One appointed by the patient, one appointed by the defendant or defendants, and a third appointed by those 2. You then present evidence to the panel in the form of written documentation. There can be no live appearances, but you can present testimony by deposition. They decide whether or not there is a breach of the standard of care. But whether you win or lose at the panel stage, you are still entitled to file a lawsuit.
So it doesn't prevent you from moving forward with your lawsuit.
Correct.
Okay, we're going to have to leave it right there for right now, but stay right there because we have to take a short break. But when we come back, we're going to take your questions about medical malpractice. Stay tuned. We'll be back in just a moment. Hello, everyone. Welcome back to the show. It's time now to take your questions for attorney Robert David about medical malpractice. And remember, you can send in your questions any time of the week to the show on Twitter, on Facebook, or by email. We have a question here about the consent form, something that we talked about a little bit earlier. You have to sign those consent forms, but if you do that, do you waive your rights to file a negligent claim? Attorney David.
Not necessarily. First of all, you always can file a claim.
Okay.
You might lose it, but you can file it. So there's nothing to prevent people from filing claims. But the consent form is pretty broad. It lists everything that can, almost everything can go wrong with a procedure. But just because something goes wrong doesn't mean there was negligence. I'll give you, if I might, a simple example. During a surgery that's going to last for 2 or 3 hours, there is a requirement that the arm be placed in this position. And if the arm is placed in that position and the patient ends up with a serious shoulder problem that can't be fixed very well, then the consent form says you recognize that as something that can happen without negligence, and you have no cause that is going to be successful. But if the arm was placed this way for several hours during the surgery, then that is a breach of the standard of care or medical malpractice or medical negligence.
Okay.
And the consent form will not control that situation.
Seems like it could be a very
But
fine
let
line.
me just add to that. In other words, some nurse, maybe not well trained, maybe the doctor who's putting them in that position doesn't read the chart as he should or she should have, and the arm is in a position that any doctor who knows anything about what he or she's doing says, whoa, that's wrong. That arm should not be like that. That's going to do real damage. Never mind that there's a risk of damage. I know that that's bad. That arm in this position, like Mr. David, Robert just showed you, that can cause real harm, and then harm results. You know, the doctor gives you the this treatment, and it's the wrong treatment, but it causes you no harm. Well, that may be negligence, but that's not a case, luckily, because you didn't get hurt.
Right. And I think maybe that plays into our next question, which comes from Patrick from Mandeville. He says, does a misdiagnosis mean medical malpractice?
Not necessarily, but often it does. If you're looking at a pathology slide and you say this pathology slide is clear, there's nothing wrong with it, but in fact there are atypical cells or cells that suggest cancer, then that slide has been misread. There is a misdiagnosis. The patient will go on for quite some time. The cancer will advance and get worse, and perhaps there will be no chance of cure by the time it is detected. Same can occur with mammograms.
Yeah. Same thing, but a little bit more on that consent form. That consent form says you can die from a tooth extraction, you can die from anything. So with consent forms, what you want to be careful about is just because some bad result is on that consent form and a bad result happened, that doesn't mean no negligence. Sometimes they did something completely negligent, and it's a bad result that's listed on that consent form. You might want to talk to a medical negligence lawyer if you have the slightest worry or wonder, did a negligence occur?
Okay. All right. Mark writes in, he says, how long does a medical malpractice case typically take? Is there an average length of time that it takes to bring these cases for?
Well, a long time is the easy answer because you have to get through the panel stage, which takes 1.5 years to 2 years.
Oh, wow.
And at the completion of the panel stage, if you're going to go forward in court, your case gets allotted to the bottom of the court's docket, and it takes another 2+ years to get to trial. So it can take a very, very long time, more than the usual tort case.
And then it could be appealed and go to the Court of Appeal, and that could add more time to it. We just had a case go to trial recently on a medical wrongful death case, and it took years to get to trial, and now we're waiting to see if defendants are going to pay the judgment or if they're going to appeal. We'll see.
Okay, so it could take a long time and again can be very costly. Okay, another one from Teresa from Mandeville. She says, does medical malpractice apply to chiropractors and other alternative medicine specialties?
It does. Almost everyone in the medical, in any kind of medically related field wants to be covered by the Louisiana Medical Malpractice Act because you are afforded the short statute of limitations, you're afforded the cap on damages. So just about everybody is. If you find a doctor who is not covered by the act, chances are that's not a doctor you want to be visiting.
Okay, and you know, I'm glad that you mentioned that because this is a point that we wanted to clear up. When we talk about medical malpractice and the lawsuits that are filed, they're not just filed against doctors. It could be against the hospital, it could be against a nurse, it could be against anyone and everyone associated with the health field. Is that correct?
Correct. Nurse practitioners, you know, internists who, interns who are doctors, residents.
Anyone in the health field. So here's a scenario that we sort of discussed a little bit earlier. Let's say that I have been to 3 or 4 doctors. I'm having issues. Nothing has been, I haven't gotten an accurate diagnosis. I finally make it to a 5th doctor who says, well, you should have had this test done, you know, many years ago. And now I'm at a point where my illness has progressed. I'm in the advanced stages here. What recourse, if any, do I have against the other doctors who I went to see?
Well, hopefully you learn that within the 3 years from the date of the first failure to diagnose. And if you have, then you have the same rights as you would ordinarily. That is, failure to diagnose is often malpractice, and you have a malpractice claim against that first doctor, or maybe the first 2 doctors.
The first 2 doctors, but again, that 3 years is critical here.
Critical.
Okay, all right. Brandon from New Orleans says, I'm on a prescription that requires regular visits to my doctor. If I miss an appointment, I won't be able to refill my prescription until I return to the doctor. However, my doctor is evasive and inaccessible. Sometimes it can take months for me to see him. Because I'm suffering during that time without a prescription, do I have some sort of action that I could bring against my doctor? Can I hold him responsible for my suffering?
I would say no. The only recommendation, if he's that bad, get another doctor.
Get a new doctor.
Get a new
Absolutely.
doctor.
That's the first thing that pops
Okay.
to mind.
Okay. All right.
You've got to have a good relationship with your doctor. And just so one point, we're not here to trash doctors. You know, the majority of doctors absolutely care about their doctors, nurses, medical providers, hospitals. They're there to tend to the sick, help people who are injured get better. We're only talking about the ones who occasionally screw up. If you have a car accident and you hurt somebody, we don't think you're a bad person either. That's why you have insurance. That's why these hospitals and doctors have insurance. But the injured people need to be compensated when negligence has caused the harm. And those who are negligent, if they're decent people, they want you to be compensated too.
Right, and as you mentioned earlier, it's not Monday morning quarterbacking, you said. That's not what we're talking about here.
Right.
Yes, you wanted to jump in.
No, that's a good point. You know, none of us gets up in the morning, gets in our car and says, I think I'm going to cause an accident today. But the best of us, the best drivers of us, sometimes do it. Sometimes we don't come to that complete stop at the stop sign. We don't see the red light. Things like that happen. That's why we have insurance. Same with the medical profession.
Okay.
Some very good doctors sometimes make mistakes. You just have to understand that.
Sure. Okay. Deb from Marrero asks, I was vacationing in Mexico and had to have an emergency medical procedure. Nothing went wrong, but if it had, would I have been able to sue for medical malpractice from the United States? For people who are traveling abroad, they need to be aware of what their rights are. So
Sounds
what
more
about
like your
this?
area, John.
Well, I do have a lot of contact with Mexico. I even have family there. But my understanding is, just like what happens to you here in the United States, here in Louisiana, the laws where the incident occurs generally dictate what your rights are. So if something happens to you in Mexico, the laws where the incident occurs dictate what rights you have, in all likelihood. But again, that would be something to talk to a lawyer about, let a law firm discuss that with you. Certainly in my office, we have contacts all over Latin America, and we have people such as myself who speak Spanish fluently. We'd be happy to investigate that. But it sounds like that didn't happen here, so good.
That was good, yes. Okay, Jimmy from Chalmette asks, can I sue my doctor for malpractice if he fails to diagnose me if he was relying on my own description of my illness? I'm not a trained medical professional. How am I supposed to know what's afflicting me?
Well, based on what you tell your doctor, he will order whatever tests he thinks are appropriate. If he does, fine. And if he doesn't, well, then you need to investigate why he did not.
Okay, so before we let you go here, what are just some important things that you want people to know about pursuing a medical malpractice claim, if in fact they believe they have reason to bring one?
It's kind of difficult for people, particularly in death cases, to come to grips with why they lost their loved one. And it may not occur to them for a long time that they should pursue a remedy. It's just a question of knowing the time limits. That's really it. Just do it before the time's up. 1 year, 3 years. 1 year from the day it popped into your head that you ought to do something really should be your rule.
To go ahead and start investigating and looking into it. Okay.
That's right.
All right, well, we have learned a lot. Thank you so very much for being with us, Attorney Robert David.
Thank you.
Thank you, Rob.
That is all the time that we have for this show, but be sure to join us next week when we will take on another area of the law and find out how to protect your rights.
Thanks to my friend Robert David, and thanks to all of you for watching and for continuing to support the show on Twitter, Facebook, and for sending your great questions. Remember to visit jrpoa.com to watch whole episodes of the show, and we'll see you next week. Hi, this is John Redmann. Thank you for joining us on this special webcast segment of John Redmann Power of Attorney. Our special guest is Robert David, preeminent attorney in medical negligence cases, someone I'm proud to have worked with on lots of cases. So let's get right to it. Robert, we've talked about medical review panels. That's when somebody wants to bring a medical negligence or a medical malpractice case. In Louisiana, they have to bring their claim to what's called the medical review panel first. The medical review panel is composed of 3 doctors, one selected by the injured party or the survivors if the injured party died, somebody selected by the defendant doctor or hospital, and then somebody selected by those first 2. What has been your experience with what kind of outcomes you can expect with those panels? What are they there for, and what kind of outcomes do you expect with those panels?
Well, the statistics pretty much tell you what outcome to expect. And they vary from year to year, but very, very little variance. I think it's about 6-7% are won by patients, and 90+% are won by the healthcare provider.
All right. So if the lawyer who decides after meeting the patient or the patient's family, if the patient didn't make it, decides that he or she wants to pursue the claim, that's after the lawyer has already had, or probably has already had, a medical doctor evaluate the medical documentation, medical records, determines to go forward. That lawyer files a request to go to a medical review panel, correct?
Correct.
Then the lawyer goes to the medical review panel, files almost like a petition, but it's a detailed summary of what medical negligence on behalf of the family the lawyer believes took place, correct?
That's correct.
And details it, and the other side gets to prepare a position paper arguing why they believe that there was no medical negligence, even if there was a unfortunate outcome. Fair statement?
Fair enough.
Okay. And if I heard your answer a minute ago correctly, the statistics in Louisiana with these medical review panels say that more than 9 times out of 10, these doctors, who are all Louisiana doctors or Louisiana medical experts, typically doctors, more than 9 times out of 10, they're going to say they're not going to find medical negligence occurred. Fair statement?
That is unfortunately correct.
Okay. What conclusions do you draw from such statistics?
Well, it's rather difficult for Louisiana doctors to testify against Louisiana doctors. And if you're on a panel and you find that there was negligence on the part of one of your cohorts, and in, let's say, the specialty of orthopedics, when there are only a fixed number of orthopedists in the state and they all go to the same meetings and conventions and social gatherings, then that person just might be criticized.
So it's sort of an understanding that many lawyers who represent injured plaintiffs, claimants, that local doctors are to testify against other doctors and say, I'm sorry, this other doctor, he screwed up. And if they get on a panel and say, that other doctor, I'm afraid he breached the standard of care, that means he committed malpractice, those are a very rare breed.
Somewhat, but you know, I don't want to paint everybody with that same brush, because there are many honorable doctors who will serve on these panels and do the right thing. And some of them, after the panel is over, if they are presented with additional facts, may change their mind, one way or the other.
Okay. Okay. All right. Well, after the medical review panel renders a decision, does the injured party win or lose at that point of the stage? Do they get paid? I know the answer, but for the benefit of our viewers, tell us.
No, that's often just the beginning. I mean, you've gotten through step 1, you've crossed the first hurdle, and you now go to court. And if you win the panel, there is a good chance that the case might get resolved by settlement, but
if
not
your
always.
evidence is that strong, then
That's right.
likely they'll want to settle with you. But if you don't win at the panel stage, but you and your medical experts believe your case is strong enough, then you can choose to go forward with an actual lawsuit in the courthouse.
Correct. I take the medical review panel, I'll bring it back to the expert who told me that you had a case if I lost, and say, now, here it is. Tell me why the panel is wrong. And if that doctor can't convince me that they're wrong, then I'm not going to pursue the claim.
Okay. Okay. Typically, and again, nuts and bolts for our viewers, does the injured person, the person who believes there was a malpractice issue, do they have to pay lawyers such as you or others who practice in this field out of their pocket for this assistance up until this point?
No. It's unreasonable to expect a patient, especially a patient who's been seriously injured, probably can't work, or if it's a spouse, even the non-working spouse has to do whatever is necessary to support the non-working spouse with medical treatment and pay for that. No one has enough money. But the insurance companies, of course, have.
Right. So it's kind of like a car accident case. If you are able to actually get past all those hurdles, and if there's indeed medical negligence, if you're able to get to the point where you're in trial or you're getting to trial and the case either settles or you're victorious, only at that point is that when the lawyer representing the claimant is paid?
That's correct. All our cases are on a contingency fee basis. We get paid if we are successful, and we don't get paid if we're not.
Same like my office. You only collect if the client has won the case and is due to collect.
Or settles the case, correct.
Okay. Now, let's change gears for a minute. Medical negligence, let's give an example for people. If someone has entered the emergency room with a problem and the doctor commits it, what's a typical example in your experience of negligence that happens when somebody goes to the emergency room thinking one thing and the doctor commits an error?
I guess the most common one is a patient who goes in the hospital with symptoms that might be related to a heart problem, a heart attack, and the patient is given a GI cocktail and said it's indigestion and sent home. There's a saying that is popular among doctors: there are more people in cemeteries that died of indigestion than any other condition.
And the joke, and why that's funny, ha-ha, is because the indigestion was not indigestion. It was
a heart attack.
It was a heart attack.
The beginning of a heart attack that could have been stopped in its tracks.
right. And that brings up the word that we use a lot when we're in trial or when we're in settlement negotiations or in debate with the other side. Differential diagnosis. Why don't you tell us how that plays into that scenario?
Well, the first thing the doctor is going to say is, what is wrong with this patient? And he or she comes up with one or two or three things. Indigestion, could be myocardial infarction. So what am I going to do with these differential diagnoses? I'm going to rule them out. You start by ruling out the most serious and life-threatening one first. You do everything you can to rule out a heart attack.
That's standard operating procedure for doctors, not only in the emergency room, but anytime a patient has a condition that becomes emergent or becomes potentially a serious threat.
Absolutely, because you're not going to die of indigestion.
Right.
But if you are having a heart attack, as unlikely as it may seem, that's
Right.
what you've got to take care of.
So to sum up, patient goes into the doctor, they ask the patient, what are you here for? Well, I have this terrible, it feels like indigestion, I took some Alka-Seltzer, whatever. The doctor says, it could be indigestion, it's probably indigestion, you know, it's probably all it is, but the doctor also knows it could be a heart attack, and it could be maybe one or two other things. The doctor's obligation, and it's not something you can deviate from, is rule out the most life-threatening, the worst possible outcomes. Because the differential diagnosis could be this diagnosis, could be a different diagnosis. Rule out the worst ones and do your EKG, do your testing, and if the testing says it's not a heart attack, move on to the less threatening. And finally, if it's just indigestion, at that point, give them an antacid or whatever and tell them to go home. Correct?
Pretty much right.
Okay. We're all out of time. We're very grateful to you, and I found this completely interesting, but I'm hoping that our viewers will go to our website, jrpoa.com, for more information, statistics, links to statistics on medical malpractice, and join us for next week's episode.